everyone. Today we're going to discuss on the topic of Hawkins versus Clayton. That is, where there is will, there is way. Most solicitors provides their clients with the facility for the storage and safekeeping of their wills. It's not surprising that the High Court's decisions in Hawkins versus Clayton, which was handed down on 8th April 1988, attracted a considerable amount of attention. In that decision, the High Court, by the majority of 3-2, held a firm of solicitor which retains client will in a safe custody was liable to the executor of the client's testatrix estate for economic losses suffered by the estate of consequences of the firm's failure. The seriousness of the implications of the decision for solicitor who retains custody of their client's will cannot be underestimated. A brief outline of the background of the plaintiff's successful appeal to the High Court is necessary before this importance of the decision. In this case, there were three main laws that have been focused on. The first law was duty of care, second was law of negligence, and third was law of tort. Now I called, further case will be explained by third.
Hi everyone. Today I am going to talk about the factual background in this decision on the safeguard. Defendant solicitor prepare and retain the will of executor. Until the year 1981, there were no steps to be taken to notify the death of the client. After that, in the year 1982, plaintiffs take action against the solicitor for their negligence. In this contract, there is a recovered the losses which were suffered as a result of the delay in taking the process of estate of executor. According to the law of Supreme Court, the law of tort was based on the duty which was on to the plaintiff personally, and the contractual claim was presented on basis that there was a contract between the plaintiffs and solicitor. Before the High Court, the plaintiff's case was presented in the following manner. Firstly, with respect to the claim in tort. In this claim, defendant solicitor breached the duty of care. And the secondly, with respect to the claim of contract. In this case, defendant solicitor breached the duty of contract. In plaintiff's claim include the late lodgement fee on the date duty return, because the defendant solicitor had October 1981. In this year, original will be lost. With respect to the client's house, plaintiffs claim he had lost the opportunity to collect the rent. As indicated, plaintiff success the lay in actions based on the negligence. The next case will be discussed by the RP.
Hi everyone, I'm going to talk about the law of negligence. In case of Hawkins versus Clayton, the decision was based on the law of negligence. This is the first time that the High Court allowed plaintiff to recover the pure economic loss due to the negligence and the omission. It is no wonder that the judgment was in favor of plaintiff to recover the economic loss due to the negligence and omissions, which was in the previous case the Sutherland Shine Council versus the Hammond, in which the judgment was in favor of the plaintiff as well. In significance of the Hawkins case, the development of the law of negligence lies in that part of that the proximity case was applied. Even in the previous case, the test had been applied to recover the liability and the relevance of the crucial factors. The High Court clearly ruled that the act of negligence and omissions are not just a reason, but that was the main cause for the plaintiff economic loss, which was affect the liabilities, and the further will carry by the CIFA.
Hello everyone, Shilpa Patel. I will continue with concurrent duties in tort and contract. In this judgment and in subsequent decision, the plaintiff has made a significant contribution to the rationalization and development of the law of negligence. Plaintiff makes a further contribution by providing the guidelines for an action of professional negligence should be brought in tort and contract. After typically well-reasoned and straightforward judgment, apart from certain limited cases, the liability of the solicitors for professional negligence will be tortious and not contractual. Plaintiff questioned the need to imply such a term into a contract when there was an identical duty of care imposed by the common law. The plaintiff again quick to point out that the solicitor would be under a concurrent coextensive contractual duty of care to his client in the case where the parties had imposed such a duty on the solicitors. Plaintiff also indicated that in some cases the term had been implied to the contract between a solicitor and the client, which operates upon the common law duty of care. At last, judgment was proved to be a significant in the development of the law, else its proximity concept. Again, I will hand it over the case for further discussion to Jyoti.
Thanks everyone. I am going to conclude the presentation with the significance of case for solicitor. As indicated earlier, this decision is also important on another level. The implications for solicitors are too important to be ignored. First, the defendant solicitors were held to own duty to take positive action to locate the executor and advise him of the existence and contents of their clients, will even though they have been specifically retained to undertake that task, and it was not part of their relevant contractual relationship. For both, the fact that the solicitors had accepted custody of the will was enough to attract liability, and the fact the solicitors retained information necessary for the plaintiff to exercise and enjoy his legal right and executor was enough. As dissenting judge pointed out, the consequences of this decision will be far as reaching, and there is nothing particularly special about the circumstances of this case that would not be capable of application to every solicitor having the custody at will. In this case, the High Court held that the defendant solicitors own a duty to the plaintiff as the executor of the district's will, while the High Court recognized the existence of duty of relevance to probably all solicitors of practitioner were given little indication of sorts of steps required to be taken in order to fulfill this duty. The High Court decision also raised the question whether a solicitor as custodian of client's will is under duty to take a reasonable step to learn of the client's death. Certainly, an obligation to take the reasonable steps to learn at the tester's death was not part of the duty formulated by the court in the hawkin. It may be that solicitors who fail to take any positive step to learn of the client's death would be regarded as having a constructive knowledge at that one, so that his consequent failure to locate and notify the executor constitutes breach of the hawkin's duty. Thank you.